Mr. Harris, you're up. 7 minutes, please. It's great to have you here today, Mr.
Thank you, Mr. Chair, and I'm happy to be here. And thank you, Mr. Corbett, for your testimony and your story. But I wonder if I can ask you this. Mr. Lekuski just spent his whole 7 minutes asking about an investigation that was closed. I understand that this legislation, if this were later after that were passed, you wouldn't be able to tell us about this investigation that was closed, would you?
I don't know. I'm not familiar with that much.
You're not familiar with the legislation, but let me tell you that what it says is that if an investigation is closed and no charges are laid, the chief elections commissioner is unable to provide any information or even comment about the investigation. So you wouldn't have been able to tell this story to Mr. Lekuski after this election is passed. Do you think that that's a helpful thing, that if an investigation takes place, you would not be able to, if no charges were laid, you couldn't comment on it?
When I became commissioner, I was concerned for the fact that we would spend a great deal of money and effort investigating something, conclude that it wasn't a matter that could go to prosecution, and we couldn't say anything publicly. So I said, I'm not going to do that. Where there's a considerable public concern, I'm going to put out at least a press release as to what we found. And that didn't go over very well with the press people at Elections Canada, but I did it anyway.
But would it bother you that this act would prevent you from issuing such a press release?
I think the public's entitled to know.
Okay. But not only would it prevent you from issuing a press release such as that, but what if you had an investigation and you had concluded that there was very serious fraud, but that you couldn't lay any charges because people were refusing to cooperate, even under the encouragement of people involved in the election? And you couldn't comment on that. Would that be in the public interest for you to be unable to tell the public that there was fraud, but you couldn't identify the perpetrators because no one would cooperate and they were under instructions to do so?
Well, I've never had to deal with that issue, and I don't know, frankly, how I would deal with that issue.
Well, would it be in the public interest for there to be a law to say that you couldn't tell the public about that?
Well, yeah. I understand your point.
Okay.
I mean, I like the idea of openness in this line of work, as much as it can be done.
You also said that investigations take quite a long time and that they're difficult sometimes to get to the end of them. Mr. Côté told us that some investigations would be aborted because people could refuse to cooperate. It seems it's almost like advice to people as to how to game the system. Go big so the investigation is really takes a long time. Tell people to refuse to cooperate, and do your calling outside the country because there's no prohibition against that. Why would some craft an Elections Act that set things up like that? Do you have any reason why no one would do that?
No, I don't. What I was describing is a relatively new phenomenon, that we don't get the cooperation that we should get from people. I found it very discouraging that people would make appointments to be interviewed and then cancel them.
I was impressed, Mr. Corbett, about your statement, and I agree with you about the 60% of the people that vote who take this very seriously as a sacred right or an obligation, and they take it seriously, and they want to have what you call a fair election with a reliable result. You call it the foundation of democracy. How can we have a situation where, the Securities Commission, in the public interest looking after the management of the stock market, the CRTC, the Fisheries and Oceans looking after fish catches, they can compel witnesses to give information and to fulfill an investigation, but this most fundamental sacred foundation of democracy, having a fair election, enforcers and commissioners such as you were and your investigators have no right to ensure that the fundamental democracy of our country has the same kind of powers to do the proper job, as you said, to seek compliance. Does that make any sense to you?
Well, it's my obligation to bring it to the attention of members of Parliament. That's what I'm doing today.
So when we see these, so you don't see any reason why this should be any different. In fact, I would suggest to you that you probably think that elections and fair elections are being run properly are far more significant than some other aspects of our society.
I believe for sure. This is much more important legislation than, say, the Fisheries Act or the, I don't know what others, I think. This is where democracy begins.
So, Mr. Corbett, I do have one question which disturbs me, and I see it in the recommendation of the Chief Electoral Officer that in terms of robocalls, for example, which you referred to, that there is a suggestion that the information be required to be kept for 1 year. Is that sufficient time? Like, for example, if an investigator decided now that they needed access to the CIMS data from the Conservative Party going back to just before the last election in April of 2011, there would be nothing to, if that didn't exist, there'd be no problem. But there could be a possibility that information would be required more than a year after an event, would there not?
I don't know that we've had enough events looked at yet to determine that. What we get are, we got complaints about robocalls, as you know, and the first thing you want to know is what kind of message did you get? Mm-hmm. Did you get the phone number of somebody calling you in, you know? Is there some way we can confirm what it is you're saying to us? And the complaints were not exactly all the same. You have to confirm the complaint before you're going to move on. Is this complaint real? So I would presume an investigator would quickly be looking for the information in the data bank, and if they had ready access to it, they could sort out the complaints. If they were, if the person doing it had registered, but frankly, we just haven't had enough experience with it yet.
Thank you, Mr. Harris. You're over your time. We'll go to Mr. Sims for 7 minutes, please.
Mr. Corbett, thank you for coming. When I first looked at this bill, I looked at the moving of the office into the DPP as something that, sure, okay, there you're looking at an exercise in independence. But then, as I spoke to people, I realized, and doing a little bit of investigating, I realized that maybe that's not such a good thing because it's more like an exercise in isolation. And some of the stuff that you said earlier, like, to me it seems like that if you're working as the chief investigator and you're looking at getting all the information that you can, a lot of this information comes from DROs, poll clerks, auditors, all these, at least in the evidence that I see.
Yes.
But that's, even though the government says that, you know, they have every right to go to them, but that's not readily available. I mean, because it seems to me that as an investigator within Elections Canada, you exercise your independence, but at the same time, you were able to see the red flags that went up from polling stations and divisions across this country.
Well, yes. I mean, I'm not sure whether you're talking about the monitoring role or the investigation role here.
The investigation.
There's a warehouse full of paper that Elections Canada has after an election. It all gets bagged up and you sort through it to find this, that, or the other thing. And that's available, but we need the elections people to find it for us in the warehouse and get into it and get access to it. That wouldn't necessarily be hindered if you were outside. I'm more concerned about being able to draw on that expertise. Elections Canada is the only center for federal election expertise in the country. You know, if you want the lawyers and you want to know how they do business, if you want to know how they run the election, if you want to know what the auditors are doing, and how they apply the law. This is what I would call applied law, not theoretical law. This is a statute that somebody has to implement in a real life scenarios. And the closer you are, it's a learning experience in this organization for investigators. How do they do business? And you want to be able to draw on the people that have been doing it for some time.
Does this go to what you said earlier, which I thought was very interesting, when you said, for the commissioner, it's not about the prosecution as much as it is about compliance.
Exactly, exactly.
And that's what plays into this, because they have that field around them where they can go back and forth with the people who do the field work, like such as the auditors. So would you agree then this is an exercise in isolating a particular office?
Well, it's going to isolate. Whether it's aimed to do that, it will. But we've had situations where there was clearly a violation of the Act, all right? And we went to the political party and said, here's what you have to do to make it right. And they said, yes, we will. And they did. So we went into a compliance agreement with them rather than a prosecution. That's an idea of getting compliance without prosecuting. My colleague, Mr. Côté, is dead right. You get into the criminal courts, the judge has got attempted murder sitting here and some other cases there, and you bring in an Elections Act case, and there isn't a lot of interest, if you want to know the truth.
Because you did mention that the DPP is probably far more concerned, well, I shouldn't say probably, they are far more concerned with criminal code offenses as opposed to this, which is really a totally different mindset if you're looking at the compliance issue. So,
I mean, I'm concerned about the adversarial context that I see coming into elections matters from time to time, and I'm concerned that we have to prosecute. Do you have any idea how many offenses there are in the Elections Act?
I have a fair idea.
Something in the vicinity of 200? Are we going to prosecute everybody for everything? Of course not. Can't possibly do that. The person I feel the sorriest for is the official agent who has to put these things together after the campaign's finished, everybody's gone home, all the euphoria's gone, and I see these, some of them are absolutely overwhelmed. Well-meaning, well-intentioned people. I've had accountants write me and say, I can't possibly sort this mess out, and I'll never be an official agent again. If you can simplify life for those people, that would be a significant step forward. And I'm off the topic here now.
No, that's quite all right. But you're well within the scope of what we want to hear. I think when it comes to the compulsion of a witness testimony, as was touched on by the current commissioner earlier, the ability to investigate or to compel testimony, and you made reference to the robocalls affair, this is a very essential part of a job in light of what you said about even now. Now with the separation of that office into DPP, it probably makes that power to compel testimony even more important.
I would think so. I don't want to dwell on robocall too much, but we had no idea what can be done on the internet by way of triggering 100,000 calls for a very small price. I mean, it was, I don't know what's coming next.
Just very quickly, I don't know if you have any comment about this, but recently I was reading about the necessity of reporting to CRTC about your scripts, about any. Do you care to comment on that? Do you have any? When it comes to compliance, do you think that's an effective measure?
I don't know. I don't even know the details of that legislation. I don't know it that well. I'm sorry.
It's okay.
Need someone else to answer that.
But certainly, looking at this in total, I mean, when you were commissioner, did anyone, and post-commissioner, anyone come to you officially from the government and say, is this really effective? Like the powers that are currently held by the competitions within the Competition Act, was that something that would benefit you in your investigations? No one's really discussed it?
No, I wouldn't say so. I'm delighted to see the penalties getting more substantial and being brought more in line with regulatory penalties and other legislation. It's not quite a full step, but it's certainly a decided improvement. There's nothing worse than spending a pile of money investigating an offense with a $5,000 fine.
So,
Sims, you can get your question in before your time, but I don't give you another one. Thanks.